All right, ladies and gentlemen, we are going to get started. We apologize about a little bit of a delay. Should be a sign-up sheet down there on the table. We are going to hear House Bill 424, House Bill 500, and HB 505. Before we start the meeting, I want to ask Dean Green if he would lead us in a word of prayer, please.
Thank you, Mr. Chairman. If you would, pray with me. Our Heavenly Father, we thank you for this day. We thank you for thy blessings. And Lord, as we come before you doing the people's business, may we be mindful that it is the people's business and we are here to do that. And Father, we just ask you to be with us, guide us, and direct us in all things. In thy holy name we ask. Amen.
Amen. All right, let's jump on into the agenda at this time. House Bill 424, Representative Ken Vance will come forward and present that bill, please.
I'm sorry, Mr. Chairman. I'll get situated in a minute.
Yeah.
Thank you, Mr. Chairman, members of the committee. I appreciate this opportunity to present this bill. I'm going to work from the substitute to House Bill 24. It's LC 480863S. And I think you all have a copy of it.
Everybody got that? Okay. Go ahead.
This bill is really to enhance the qualifications for the highest constitutional office in each of your counties, and that office is the office of the sheriff. What this bill does, and it's a pretty short bill, and I think y'all seen a version or so of it previously before I got here, but it states this: at the time of qualifying as a candidate for the office of sheriff, the person is a certified peace officer as defined in Chapter 8, Title 35 OCGA, and is in good standing with the Georgia Peace Officers Training Standards and Training Council, and I'll refer to that later as POST, if y'all don't mind me shortening it a little bit. The Executive Director of POST shall create and provide an affidavit attesting to such person's compliance with this subparagraph, which I'll enumerate later. And that affidavit shall be signed by the executive director and the person or his designee and the person seeking to qualify for the office of sheriff. It shall be presented to the proper elections official prior to the end of the established period of qualification in order to qualify as a candidate. The term "in good standing" with POST means that an officer, a peace officer, has never had his or her peace officer certification revoked or suspended by POST, and upon the opening date of the established period of qualification is not under any sanction imposed by Georgia Post. Now this section 4, which starts on line 45, I affectionately refer to it as the Danny Mathis Amendment, that says each person offering to run for the office of sheriff and who is otherwise qualified shall be allowed, prior to qualifying and at his or her own expense, that they can attend the basic law enforcement mandate course for peace officers, which, by the way, is 11 weeks, as a pre-service candidate. The Post Council shall work to ensure that space is available for such individuals to attend the course, and they shall be entitled to reimbursement of his or her expenses if they are subsequently elected to the office of sheriff. The reimbursement for expenses shall be limited to the cost of tuition, course uniforms, course equipment, and shall be paid for by the office of sheriff to which that person is elected. So what we've tried to do, ladies and gentlemen, is offer a path, if you will, a path to running for sheriff if they're not already certified. And that's the bill in a nutshell, and I'd be happy and honored to try to answer any questions.
There's a few questions here. Let's move down. Number 28, who is that?
Thank you, Mr. Chairman.
Dean Green.
Thank you. I want to be perfectly clear. If I wanted to run for sheriff, and I'm not certified, but I know way before the election that I want to run for sheriff, I do not need a sponsor from the sheriff's department or the police department. I can do this if there is room for me at the post.
That's correct, and this does two things, Chairman Green. One, it says post will create a space for you in that class.
Okay.
Okay? Secondly, it gives you time to prepare to be the sheriff prior to qualifications. And like I said, if you win, they'll reimburse you for your costs that are enumerated in this bill.
Okay. Good. Thank you. Thank you, Mr. Chairman.
That sounds very fair to the chairman here. Let's see what the other members of the committee have to say. Number 29 down there. Representative Ridley.
Just to clarify for the reimbursement, does tuition include the housing expense?
It's not in this bill, sir.
So you could go, but you'd have to pay for your own housing.
Correct.
So people who are elected now, because they go after they're elected, is housing provided for them?
But that's an added expense to the county.
An expense for the county?
Correct.
All right, so the county could choose to reimburse them for that?
Correct.
All right, thank you.
Okay. All right. Any other questions for the author of the bill? I do know that we had some people that wanted to speak to the bill. I believe Sheriff Association's here. Terry Norris, do you want to speak to the bill?
I don't want to talk it to death, Mr. Chairman. If there's any questions, I'd be more than happy to answer. This is a helpful bill. Would you like me to come up?
If you can go to the podium, please.
This is, as Representative Ken Vance said, this is an important provision. It addresses qualifications and training enhancements. And we look at it as an enhancement because you're prepared for that office before you go. There are a couple of other practical reasons that this is an important change in the current law. The law as it stands now was written many years ago, and it did provide for the 6 months subsequent to taking office to get the training. There's a couple of practical reasons that is not a practical way to approach it at this time. One is, in these days and times, you must pass a physical agility test before you can even enter the training. The physical agility test, I probably could pass it. There are a lot of people that might not. If you do not pass the test, you cannot attend the class, you cannot get certified, and you cannot become sheriff, because if you're not certified within the current 6 months, the probate judge would have to, post would have to contact the probate judge, who would have to declare the office vacant, and you'd have to have a special election for that office. The second reason is there's also a psychological test, and it's a good thing I was certified back in the early 90s, because I didn't have to take this test. And of course, by then, at that time, I hadn't got to deal with the General Assembly for all these years. So that is an important consideration as well. I act like I do because of sheriffs and y'all, so y'all are partly to blame because I'm the way I am.
We hear duly noted. I don't know.
But there's a transition issue as well. If a person had never been certified, likely they don't know much about law enforcement. And if they don't know much about law enforcement, they likely don't know much about the sheriff's office. They may not even know who works in the sheriff's office, whether there's a jail or not. So in terms of the current law and allowing 6 months, you would be requiring someone to win, to run, get qualified, win the election, take office on January 1, and then 11 of the first 24 weeks of taking office, you would be gone to another location. It'd be hard to transition in, not knowing anything about the sheriff's office, being gone. It would hurt you, I think, in a couple of ways. I think it would hurt you because you'd be on the phone constantly talking to people that you really don't know, unless you brought some people in, about what's going on back at home in the sheriff's office. And I think it would take away from or detract from your ability to actually sit through the 11 weeks of training.
Okay.
So those are my points, Mr. Chairman. Any questions, I'll be glad to answer.
Thank you. Let's see, number 12 down there. Who's that? Chairman Taylor?
It's me. I'm full
Yes,
of
ma'am.
questions today.
Yes, ma'am.
Just a couple things, especially with the physical portion of that. Is this going to be in any way an age problem or an age discrimination?
Well, it is already the law
Okay.
and post-council rule. So if it is, it's what it is. So it's
Okay.
and I didn't have to take that either because I've been here a while.
And if I may follow up,
Yes, go ahead, please.
and on line 45, where it starts talking about each person who qualifies can take this. They're not obligated to go take those courses. Is that correct?
I don't have the bill in front of
Okay.
me. Is that the pre-service section?
Yeah, it's the pre-service
Yes,
training.
yes,
They can if they want, but
that's
they
the
don't have to.
availability, yes, ma'am.
Okay. Yeah,
We'll let the author of
it's
the
a
bill
shall.
speak to that.
At one time, I thought it was a must, but it's not. It's a shall.
Okay,
Okay, thank you.
all right. Number 10 down there. Who is number 10? Is that Representative Evans?
Yes.
Go ahead.
Thank you, Chairman,
Yes, ma'am.
and thank you for bringing the bill. And I just am kind of curious, like, how many sheriffs have not been law enforcement officers in our state? Like, what's,
If I might answer that, Representative Vance?
Yes, sir.
I will try, and this will be on.
The chairman will let you answer that question, too.
Well, I thought she asked.
Go ahead.
Oh, yes, sir, Mr. Chairman.
Go ahead.
Can I do it now?
Go ahead.
Yes, sir. In my 28 years, I can recall 3.
only 3.
Right. And it's a little bit different day for attending mandate. In years past, and during the time that the 3 I recall went to mandate, subsequent to taking office, those training academies at that time were operated more locally. So there was local boards, and there was a lot of influence locally on the course. And frankly, it was not as structured as it is now. Now, most of our mandate courses are going through the Georgia Public Training Center. There's a lot of uniformity in the way they do that training. So in years past, we had one that I recollect is Grady County. He was in his 70s when he became sheriff. He could not be sheriff now because he could not probably have passed these prerequisites.
Okay. All right. Okay. At this time, we don't have any other questions, and we don't have anyone else who has signed up to speak for to the bill. So what would be the desire of this committee, the will of this committee?
Second.
Okay, there's a motion made and a second to do pass, and that's going to be House Bill 424, working off LC 480863S. All those in favor say aye. Aye. All those opposed, same sign. Motion carries unanimously. Thank you, Mr. Vance.
Thank you, committee. I really appreciate it.
Yes, sir. All right. At this time, we're going to move on to House Bill. Chairman Chokus and Chairman Silcox. Does one of y'all have to go to another meeting? Okay. Okay, let's go with Chairman Silcox. House Bill 500 at this time is going to be called.
Thank you, Mr. Chairman.
Thank you very
and
much.
committee members. I bring to y'all this afternoon House Bill 500.
Okay.
And I bring you this bill because Chief DeSimone, our chief in Sandy Springs, is near and dear to me. And he does an outstanding job. But I think a lot of times in a lot of these crimes that are committed, a thing that gets overlooked is the equipment that's damaged or torn up. And I have on good authority from him that a lot of the specialized equipment that's on a police car can mean the cost of that car to replace all that is upwards of $100,000 with specialized equipment. And so with that being said, I do think that making it a crime to aid or abet in the damage of a police car should be a serious offense. And should be a new crime because I think a lot of people do not have regard for the property of police officers the way that they should. And it's very expensive to replace, especially given all the supply chain issues that we've had in the last few years. Some of that equipment takes a long time to replace. So with that, I'll just say that, of course, this is creating the offense of arson of a law enforcement vehicle if someone, aids or abets knowingly, and the penalty would be $100,000, not less than 5, not more than 20 years as a punishment.
Upon conviction.
Yes, of course. Mm-hmm.
Any questions for the author of the bill at this time? Let's see, number 8 here. Representative Neal.
Yes, Mr. Chairman, thank you, Madam Chair, for the bill. I do appreciate the effort, and I do want to see if I can make a recommendation. So currently, I haven't had to write this in a very long time. So currently, the way this is being handled is there's already a code section, 16.7.24, interference with government property, and that covers everything related to property. That includes cars, you name it.
Right.
So I don't oppose the bill as a whole, but I do oppose some of the penalties because the way we determine if it's a misdemeanor or felony is based on the cost, the amount of the damage. So currently, if it's under $500, it's a misdemeanor. If it's over $500, it's a felony. Would you be amenable to adjusting the current bill you have to match the bill that is kind of already pre-existing that's kind of similar?
I guess one clarification. So you're saying if the damage to the vehicle is less than $500.
Right, so the damage to the
that it would be-
vehicle or any government property, the code section we currently write is 16.7.24, and it's a misdemeanor if it's under 500. If it's over 500, it's a felony. And so arson, pretty much anything you light on fire is going to be over 500, especially if it's on a police car. So I feel like by properly adjusting the code section to match what the code section is already for government property would be more appropriate, and then I would love to support this bill.
I appreciate that. I guess I haven't seen personally. We had a small fender bender. My husband was in a parking lot recently, and it was the tiniest amount of damage. And to fix it was $1,500. I just don't see damage to a vehicle, and maybe we could get some input from Chairman Lumsden on this with his past experience.
But to your point, it would be like if it's $1,500,
Right.
it's a felony.
Let's let lead counsel weigh in on that. Do you have a?
So the proposal is to amend instead of adding a new code section, amend 16.7.24 to add a new subsection C relating to the cost of the amount of damage and make that a felony. Is that what you're saying?
Well, no, I'm just saying just make it match the current interference with government property, which is if it's above 500, it's a felony. If it's below,
Right now it says they're both a misdemeanor, so I'm not sure where the 500 in 16.7.24.
16.7.24. Hold on.
We'll give you a moment. We'll come back to that if that's
Okay.
if that's okay.
Okay.
Number 19 here. Representative Sainz.
Thank you, Mr. Chairman, and thank you, Chairman Silcox, for bringing this. Is it not true that currently a lot of departments are facing huge backlogs in purchasing vehicles because of the manufacturing bottleneck?
Exactly. Yeah. I agree with you, and there have been substantial bottlenecks throughout the auto industry because the lack of chips. Computer chips to replace existing vehicles. So I do think that a police car is kind of special that way because it is harder to replace right now. And like I said, a lot of the equipment would be even longer than getting another vehicle.
Go ahead.
And quick follow-up, Mr. Chairman, and with that bottleneck, and especially the smaller departments that don't have necessarily additional reserve cars, when a damage occurs like this, we're putting a specific strain on small departments and putting those citizens in that area at risk of not being able to be serviced.
Absolutely.
Thank you. Appreciate the bill.
Thank you, Mr.
Yeah, I
Chairman.
think it's kind of hard to comparing apples to apples and oranges here. I mean, you can go online right now and Google, and you can find a 2021 Suburban all across the country. But go try to Google for a 2021 Tahoe or Suburban decked out with all the equipment
Exactly.
ready to go, 10.8 in service.
Yeah.
And you can't hardly do that.
No.
And
you
because of
certainly can't do
that, because of that specialization, it puts that into another category all its own. So that's one thing I want the committee to be aware of. Number 12 over here, who is
At the
that?
appropriate time, I'd like to make a motion.
Okay, let's just one moment. Number 10, Chairman,
Yeah, thank you, Mr.
Representative Evans.
Yes, thank you, Chairman. Yeah, all right. And thank you for bringing the bill. I definitely think this is a serious offense, but I am a little bit concerned about a mandatory minimum, which is the less than 5 years. Can you give any examples for other crimes that are not less than 5 years? Any comparable crimes or?
I believe that's the threshold for a felony, if I'm not mistaken.
Is that?
All right, let's go with number 21. Representative Crowe.
Thank you, Mr. Chairman. Just to Representative Neal's point, I think if you damage a vehicle, a law enforcement vehicle, by means of fire or explosive, I don't see any way it would be less than $500. So I think that discussion is probably, I don't think it's one we necessarily need to have, because I don't think there would be an occasion where it would be less than $500. And so, and the threshold for a felony is typically 1 year, anything more than 1 year. But there are several, and I can't think of any right offhand, maybe Jenna could help, but there are several 5-year minimum felonies, especially when it's related to law enforcement.
Okay, thank you. Number 8 here. Yes,
If it's appropriate,
Representative.
Mr. Chair, I would like to, can I call up a witness?
we'll get to those here in just
Go ahead.
one moment.
Mhm.
Number 9 down there.
Thank you. I was just wondering, would this still apply if a kid threw a Molotov cocktail at a car while it was moving, the police car, and he had bad aim and hit a hubcap? And so would he still be looking at 5 years in prison, mandatory minimum? And I know the price to replace a hubcap, but I don't think it would warrant 5 years.
If the Molotov cocktail was on fire and it was an explosive, I think this is part of the problem is we have a lack of respect for officers and their equipment in our communities.
Oh, I totally agree with that. I'm just trying to get to the, I share the concerns of two of my colleagues, that there could be a situation where the damage intended doesn't occur because of luck, bad aim, whatever.
But
And
why
so-
would they be
and
even
so-
throwing something at a
And
police
so
car
it's the
then?
fact that they attempted, then they should get 5 years. That's what you're saying.
Well, I guess if you throw something, I think it's really clear that your intent was to damage something.
Yeah, that's why I just asked you. So it's the fact that they attempted to do it, even if it's not successful, then they should get 5 years minimum.
If you attempt to blow up something, I think you should probably go to prison.
Okay, so, but that's not my question about trying to blow up. You're talking
You said
about, you're
Molotov
talking about a
cocktail.
bomb now, explosive. Okay, thank you.
Most Molotov cocktails I've ever saw blow up, so I'm kind of confused on that.
Yeah, no, I understand.
I'm-
My example may not have been the best, but I'm talking about any type of inflammatory object, not necessarily an explosive that causes some damage. But if you're saying any attempt to do any type of damage in this way, even if it's not a Molotov cocktail, they're looking at 5 years minimum.
And again, this has to be proven in court. You have to be found
You
guilty
have to be
of that.
convicted, yes.
We're not convicting people on attempts here. Number 29, who do we have there? Representative Ridley?
I'm generally in favor of this bill, but back to the mandatory minimum of 5 years. When a person commits the offense, so it's like it talks about encourages. So if you're convicted of encouraging, so you're a dumb 18-year-old kid, you're at an event, it goes wrong, and they light a cop car on fire, and you're yelling, yeah, and you're a dumb 18-year-old kid, and they convict you of 5 years. That's kind of ruining somebody's life when they're an 18-year-old kid and they were just caught up in the moment when they actually didn't even commit the crime. They're just in the crowd yelling, yeah.
Thank
Okay.
you. Thank you for your comment.
Duly noted. Number 26.
And with all due respect, when you start throwing Molotov cocktails or even encouraging, it's with malicious intent. And you're also putting somebody else's life in danger. And I can tell you, it's not just the rural law enforcement agencies that have limited expense. You know, I worked for an agency and was the commissioner. We had about 1,200 cars, and I've been going to riot since 1969. And I've been to some where they damaged 6, 8, 10 cars, and you know, even for the state budget, that's a horrific expense. But I go back, you know, it's malicious intent. They're trying to do damage. We all believe in peaceful demonstrations, but when you start throwing Molotov cocktails and damaging cars to that kind of extent, somebody needs to be adjudicated.
Okay. One more question here, then we're going to hear from some folks that want to speak to the bill. Number 8. Representative Neal.
Yes, sir. Thank you, Mr. Chair, for giving me the time. So I support the bill. I just want to get the code sections right and the penalties right. So clarification, the code section is 16723, where it outlines damage that's above 500 is a felony and below 500 is a misdemeanor. So what I'm trying to do is just simply make it comparable, and I think adjusting it based on a misdemeanor versus a felony will satisfy some of the issues that others are having as far as the 18-year-old kid and just randomness when it comes to these occurrences. But it accounts for the current law we have to kind of match to comparable damage. Does that make sense?
I understand what you're saying, but I just don't think there's going to be a case where it's less than $500, honestly. I just don't think there is.
Okay. Let's go back one more time. Representative Crowe.
Thank you. I think that the code section she's talking about, 16723, is criminal damage to property second degree, which is a 500, and that's to any property. I don't think that comparing criminal damage to property, second degree criminal damage to property, to damaging property via fire or explosive is really the same thing. So again, I don't know that there's a need to delineate between a dollar amount for whether it's a misdemeanor or felony.
Okay.
Thank you.
All right, this time we've got some people that have signed up to speak to the bill. Let's see. Maisie, would you like to come speak?
Thank you, Mr. Chairman and members of the committee. I am Maisie Lynn Gerton, Executive Director of the Georgia Association of Criminal Defense Lawyers. I don't know how much the chairman and committee would like for me to weigh in on some of the law that's been discussed today, but I would be happy to if it would be helpful. I've heard a few inadvertent misstatements.
Okay.
For instance, to rise to the level of a felony offense, it simply is a 1 year or more exposure of incarceration sentence. It doesn't start at 5 years, it starts at 1 year. We do have a law in the books, as the representative was discussing. It's interference with government property. It's 16724, which is right now today. If someone were to damage a law enforcement vehicle of any type, they would be subject to a felony prosecution. They would face 1 to 5 years, and the cost of that damage could be returned to the locality through our restitution provisions. Our restitution provisions are very broad. They are found in Title 17, Chapter 14, Article 1, and it is essentially everything that the victim, in this case it would be the government, whoever owns that law enforcement vehicle, whatever they've lost, they have a right to get back, and the sentencing judge can make that part of the sentence. It's a hearing that is held so that there's proof to show what the damages were and what the costs are, and it is as enforceable as the fines are. And when you consider that over 80% of the prosecutions that happen in our state are happening to people who can't afford a lawyer and are provided one on the taxpayer's dime, that restitution's probably not coming back, nor would the fine ever come back. So to the extent that this is about getting that money, I really don't think the criminal legal system is the way to get those cars replaced. However, those provisions are available, and you can already get all that today. I'm often here reminding you all that increasing punishment severity does very little to deter crime. In fact, when people go to prison, it often exacerbates their potential to recidivate. What does deter crime is a certainty of being caught and aging. People tend to age out of criminal behavior. We see it start to decline as the frontal lobe fully develops in the mid-20s, and then we see a much more steep decline at about the age of 35. Obviously, it's a policy decision as to whether or not you all believe that increasing this penalty to 5 to 20 will deter this type of behavior. The evidence in the world and these studies that have been done show that it won't. The other correction I do think is important to make, and I am grateful to the sponsor for the scheme that is being proposed, in that it is not a mandatory minimum sentence. And I hope that it will remain that way. As drafted, this bill does set a floor of 5 years, which we, again, believe 1 year is sufficient as a floor, considering that the judges have the discretion to go up to 5 right now. But there is not that magical language that gets put in sometimes requiring those 5 years to be served. So until that language, if that language were to be added, I would be having a different conversation with you about it. But this is not a mandatory minimum as drafted today, and we're very appreciative of that. Chairman Silcox.
So in other words, it could be worse for you, is that what?
It could be worse.
Thank you
I
for
can admit
acknowledging
the
that.
truth of all these
Thank you.
things.
Thank
It could
you.
be worse.
Thank you.
But we think the law is sufficient today, and you could rely on it.
Okay. Thank you very much.
If there are any questions, I'll stay, but otherwise I'll sit down.
Anyone else? Anyone else here like to speak about this? I see the prosecuting attorney's counsel back there. Anything you want to mention on this? Just want to be.
We're in support of the bill.
Okay. All right.
And what Ms. Mason-Lynn said is correct.
Okay. All right. I do believe that Representative Neal wanted to ask a question from Vince back there in the audience. If you would you like to come to the podium? We just. Go ahead. Go ahead.
And if you would just give me your experience, like I said, I support the bill. We're just I just want to get it right. Yeah, so go ahead, feel free. In reference to the charging of government vehicles and the cost of above or below 500 or not.
The cost of the cars are going to be way more than $500
Yes.
for the equipment and everything that's in there. I would say upwards into the $50,000 to $60,000 per car if you want to factor in all the equipment that we have in them at the time. And your specialized vehicles, I would say they probably have upwards past $100,000 of equipment in them when you get to our reconstruction teams, stuff like that.
Okay. All right. Thank you.
All right, thank you.
Yes, sir.
Thank you for being with us. Okay. All right. Now, the posture that we're in, what would be the will of the committee? Okay. There's a
I make a motion to move do pass.
Motion do pass and a second. House Bill 500, LC 480852. All those in favor, please say aye. Aye. All those opposed, same sign. Okay, motion carries. Ayes clearly have it. Thank you very much.
Thank you, Mr. Chairman.
Now we're going to move on to House Bill 505. Representative Chairman Mike Chokas. Always a pleasure to see you here in our committee. Chairman Chokas.
Thank you. Thank you, Mr. Chairman, members of the committee. I bring before you House Bill 505, LC 480853. And this measure changes the designation for riot from a misdemeanor to a felony. And let me read you the legal definition of riot. 2 or more persons who shall do an unlawful act of violence or any other act in a violent and tumultuous manner commit the offense of riot. And that's the reason for the bill, sir, is because we feel that when violence is involved, then it should be considered a felony, that the penalty of a misdemeanor is not sufficient for the act of a riot. And I'll be happy to go over the bill on the existing law, the changes are on 13 and 14. Any person who violates subsection A of the code section are guilty of felony punishable by imprisonment of not less than 1 and not more than 20 years. And then on line 22, we add riot as number 15. And it's a simple bill. In my opinion, it's a business-friendly bill. I've seen experiences at home, and I don't mind telling everyone what happened, and Colonel Hitchens remembers this, is when we had the tornado come through Americus, Georgia. Citizens became, there was no power. They were out on the streets, started a riot, and vandalized small businesses. There was a Radio Shack in my community that, they even took the shelves out. So that's why I bring before you this bill, and I'll be happy to entertain any questions.
Okay. For 29 down there, Representative Ridley.
So I just want to clarify how reading this correctly. A riot is any two people who commit an unlawful act of violence. So you have 3 guys in a bar, and it's 2-on-1 in a bar fight. The two could, because it is an act of violence, because they're in a physical altercation, they could be charged with felony rioting at that point.
That's a very good question. If you look at the other part of the law, a violent and tumultuous manner to commit an offensive riot, and then I don't think that you could utilize that, to be perfectly frank with you. A bar fight between 2 or more people, I don't think would be considered a riot, and I think that the district attorney, if they would like to speak to that and how that would be addressed, I would be happy if Mr. Skandalakis would get up here.
Yes, Mr. Skandalakis, if you'd like to come to the podium and weigh in on that, would be great. Okay.
I was trying to keep a low profile.
That's all right. You're not.
I was going to get up and rebut some of what Terry Norris said, but I don't think I have to. I don't think in that situation that we would. I don't think in that situation a DA would charge riot. I know in my 25 years, when we think of a riot, we're thinking of a number of people getting together for the purposes of committing violence against property or people. So I don't think. In my experience, the answer is no.
And in these days, some DAs are choosing what cases they're going to prosecute, what crimes they're going to prosecute. Is that correct?
Trying to put me on the spot, right?
Okay.
I'm with the Prosecuting Attorneys Council, by the way.
All right. Thank you. All right. Any other questions for the chairman at this time? Representative Evans?
Yes.
Yes. I'm sorry.
If someone is in, found guilty and they're sentenced to 1 year, I'm just kind of curious, how often do people usually serve? Like,
That is totally up to the judge, and they have to be convicted before the sentence is imposed.
Mm-hmm.
And so, I'm in no way able to predict what a judge would do under what circumstances.
Okay. Number 26. Who was that? Chairman Hitchens?
With regard to with the sentencing, of course, it's up to the judge. But typically, once they're in the prison system, what happens is they go before the parole board, and they're eligible for parole in most cases after 1/3 of the sentence. So if they went for a year, they could get out in 4 months. Based on their behavior in prison and the mitigating facts with regard to why they're there.
Thank you.
Thank you, Chairman. Okay, the posture of the committee, there are no more questions for the author of the bill. We do have someone else who would like to speak to the bill. If you'd like to come forward. Could this bill be made worse for you, or?
I would, I don't think I plead the fifth on that, but I
Okay.
would reserve comment. for
Go
some
ahead, we
other
want to hear from you,
time.
please, go ahead.
I will not belabor the deterrence message that I've already sent. I do want to give you some background on this particular code section. 161130 was codified back in 1863, and it was hasn't been substantially revised since 1933. I think if we all look back at the cycles of how politics and the law have responded to some civil actions, we might see some patterns in how this law has been applied and how it has been updated. And the fact that it hasn't been updated in quite some time, I do think is telling. So a couple of things that have come up today that I also wanted to address is this idea of the word violent. So this code section, because it hasn't been updated in so long, doesn't have the benefit of modern jurisprudence or legislative insight to define well the terms that are used in it to ensure that the law is crafted specifically and constitutionally to target the actual behavior that you are trying to stop. Violent. Is violent the kind of thing that we know it when we see it? Because I will say, I'm not sure I think that pulling shelves off of a commercial retail business is necessarily violent. I could imagine how it could become violent, but that kind of behavior could span quite a lot of things. Like, is it someone, pulling it off? Are they pulling it off and using it offensively at someone? It could be a range. And when we look back at the case law on this code section, there too, the behavior that's constituted as violent ranges from mere threats of violence, where 3 people were involved and one person said, "I'm going to get this other person to hurt you." That was found to be violent, all the way up to the kinds of physical harm that we can all imagine right now in this moment as violent. If you are going to subject a Georgia citizen to up to 20 years of incarceration in one of our prisons, you ought to do it with clear notice of what the behavior is you want to disallow. You should not be using vague terms like violence and tumultuous. It's just been too long since this code section's been looked at. It's much too vague. And I would just encourage you to spend either more time on it to make sure that you really are narrowing exactly what you want to prohibit, considering the history of how this law has been used and applied in our state. That's all I have.
Interesting perspective from you there, Maisie. I
You're welcome.
appreciate that.
Here to entertain and educate as I
Thank
can.
you. Thank you very much.
Sure.
All right, let's see, number 19.
I had a question for the testimony. In relation to the pulling off shelves and a relatively what might be in a common sense considered unviolent behavior, do you have any examples where this code section was applied to an individual and that person was successfully prosecuted for something to that illusion?
Well, so like what I was saying, one of the instances that I was citing was that there was a successful prosecution under this code section for a mere threat. So, I don't have an example of someone pulling a shelf off of a store wall, no. But mere threat is going to rise to the level under our current case law of violence and subject someone to up to 20 years in prison under this piece of legislation.
Terroristic threat would also be a felony charge, correct?
Right. So depending on how the threat is made, if it met the elements of terroristic threat rather than riot, then lenity could potentially pull it into the terroristic threats as a matter of sentencing, as a matter of law, which would be a lesser punishment than this bill would put forward. And as much as I enjoy bantering with Mr. Skandalakis over prosecutorial discretion, I do find Mr. Skandalakis to be one of the most reasonable prosecutors we've had in our state over the years.
Wow.
And in fact, did some litigation when I was a law student intern and used his prosecutorial practices as an example of someone who handles their discretion thoughtfully and reasonably. I can't say that about everyone that is elected now or going forward. And so I think it is incumbent on you to line up the parameters of what their discretion is to be for him to come in here and say he doesn't think a prosecutor would charge riot in the example that was given, I don't believe Pete Scandalakis would ever do that. But there are 50 prosecutors in the state who are not Pete Scandalakis. And part of what they need is guidance from this body on how they are supposed to enforce, what laws they are to enforce with their discretion.
Thank you. Okay, number 29, here, Representative Ridley.
So you talked about like the vague definition of violence.
Yes.
So wouldn't that leave it up to the judge then to decide what is violence? If the definition is so vague, the judge could be like, well, that's not violent, so it doesn't meet the criteria?
Well, it could be up to the fact finder, yes, to decide if it rises to the level of violence. And I'm going to just say any prosecutor worth their salt is going to bring to their closing argument what the definitions of violence are under our law. And like I've said with Chairman Saines, a mere threat has historically risen to that level. But like I said, the case law on this code section is quite dated. This is not a very active code section today in our jurisprudence. So
What about that
time would tell what the courts are going to say about it today.
What about that little part of the law where you have to be convicted by a jury of your peers? That comes into play somewhere too, doesn't it?
Well, of course it does.
Yeah.
But we're talking here about the element of the crime that has to be proven. And if it's a vague crime with a very broad definition of violence, that proof is exceptionally easy.
Okay.
And so if you want to expose someone to 20 years in prison without really narrowing down what that bad behavior is, I think that is problematic because you're opening the door for those fact finders to make that decision.
Representative Neal.
Yeah, so I actually had this as in my notes as far as trying to define violence. So outside of mere threat, what is the current list of, is there a list currently in the code section of what
No,
is
there's not a list of what constitutes violent in the code, but there are cases that have been decided over time wherein the facts of the case are considered by the court, and the court will say that yes, this behavior rose to the level of violent for 16-11-30.
Okay.
But unfortunately, fortunately, there is no list because it's.
Okay.
Gotcha. Thank you.
Yeah.
No, Representative Crowe.
Thank you, Mr. Chairman. I think this is one of those rare but pleasant occasions when Maisie Lynn and I agree.
I love those moments.
I think you just made the argument a moment ago for our mandatory minimums in the last bill because you just argued against judicial and prosecutorial discretion. So thank you for doing that. Because that's the reason that you don't believe everybody would act as Pete Scandalakis would. That's why we put in mandatory minimums, because we don't believe every other judge would act in a way that would be what we would like for them to do. And also, as far as updating this code, I think you're right. It has been a long time, and I think that they didn't have rioting as we see now with the amount of damage and destruction. So I appreciate Chairman Chokas bringing this in and updating that. I think that it's you know it when you see it. And Mr. Chairman, at the appropriate time, I'd like to move we do pass.
We'll recognize you now for that do pass motion. Is there a second? All those in favor say aye. All those opposed, like sign. Okay. Ayes clearly have it. Your bill moves on.
Thank you, Mr. Chairman, members of the committee.
There being no further business before this committee today, we are adjourned. Please make sure you check in with your other chairman. There are a lot of meetings going on, and your votes are probably needed somewhere else.